Welcome to the Joint Veterans Endorsement Interviews for Judicial Candidates. At the outset, we would like to formally recognize and thank our sponsoring organizations for making today's events possible. Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, and Judge Jacob Reynolds from Department 29. We are honored to have all of you with us today. Before we begin the interviews, let's review the rules and format. First, the panel members will introduce themselves by stating their names and the organization they represent. Next, each candidate will introduce themselves. Please include the office you are running for and explain why you are seeking that position. We will then proceed to the interview portion. In the interest of fairness to all participants, we will strictly enforce the time limits. Each candidate will have 1 minute and 30 seconds to answer each question. When you have 15 seconds remaining, I will get your attention and let you know. When your time has expired, you may finish your sentence, but then you will be asked to conclude. Panel members will not be permitted to ask follow-up questions. After all panel members have completed their questions, each candidate will be given 1 minute to make a closing statement. Thank you. We will start on the end with Frank.
How are you guys doing? My name is Frank Friends. I'm here with Veterans in Politics. I'm also a family court observer.
J.P. Edwards, Armed Forces Chamber.
Andre Haynes, Armed Forces Chamber.
Yadasha Jones, Veterans in Politics.
Martin Walker, Nevada Veterans Association.
Austin Beaumont, I am a candidate for District Court Judge in Department 8.
Judge Jessica Peterson, I am your current judge sitting on the bench in Department 8.
Thank you. Could you also tell us why you are running for the position?
I was going to let
I am running for this position because I am a trial attorney and the district court is a trial department. I believe that Clark County needs someone who understands what trials are about and moreover that understands the people of Clark County. I have a long experience before law, running successful businesses, running all different types of industries and different sorts of positions prior to becoming an attorney. I understand what it's like to work for a living. I understand the problems of the people that come before the court. And moreover, I understand the law that applies to the people that come before the court. And I actually care about everything that's happening in the courtroom. I believe it's important to treat people with kindness, decency, and real empathy because people who are in court generally aren't having the best day. So I think it's important to make sure that they know that I hear them and that their needs and their wants are respected.
Jessica Peterson, I have been your district court judge on the bench since 2021. Prior to that, I was a 20-year practicing attorney, 7 years in Michigan, 13 years out here. I moved out here in 2007. I've practiced in all areas of the law. I like to say I've been from municipal court all the way up to the federal district court and everything in between. The only court that I haven't practiced in was the United States Supreme Court. I had all different types of cases. I represented plaintiffs, I represented defendants, I represented businesses, I represented individuals, and have handled all different types of cases. As a judge, I have presided over 27 jury trials, 24 civil trials, 3 criminal trials. None of those have gone, all of those have gone to verdict. None of them have been reversed. I've been either affirmed or they've settled up in the Supreme Court when they have been appealed. And I believe that I bring a balanced approach to justice and that I am fair to everybody that comes in. I have been lauded by my colleagues as being fair, being impartial, being thoughtful, being prepared always. And that is what I will continue to do if the wonderful people of the state of Nevada decide to re-elect me again.
Thank you so much. We're going to start our questions and begin with panel member Mr. Martin Walker.
Good morning again. A significant portion of the public is concerned that lenient sentencing erodes public safety and minimizes the suffering of victims. Conversely, many advocates argue that incarceration without understanding or addressing underlying service-connected trauma like PTSD or TBI doesn't mitigate recidivism and doesn't adequately improve public safety. Judge Beaumont, given that your background is rooted in prosecution and lies and ties to law enforcement, how can you pivot from a prosecutorial mindset to one that weighs the benefits of veteran rehabilitation? And for both of you, what specific criteria would you use to determine when a veteran's service-connected circumstances make them good candidates for diversionary or alternative sentencing versus punitive sentences?
So, to the first part of your question, as a prosecutor, I think that the public generally believes that we're just out to put people in prison, and that's just not the case. Every case that comes in front of me, we work with defense counsel on to try to figure out what the best possible resolution is for everyone. I have voluntarily spoken with defendants when I find out, I'm sorry, not defendants, but with defense counsel, when I find out that their defendant is a veteran in some way, because we have the Veterans Court. And the Veterans Court I've seen work very well for people who have PTSD issues, where we can see that these crimes are committed by something that has caused them to not necessarily adapt well to their current environment. And I'm sensitive to that, and I understand that. Many people in my family, my immediate family, are in the military currently and are ex-military, so I'm very aware of how certain things can affect some people's ability to function. So it's not as though I'm looking at these cases as, you know, you've done something wrong and you must pay. There are real empathetic issues that you have to deal with as a prosecutor in every case. So because we work those cases out before we even get to district court most of the time, we've already done the process of vetting these things out and looking at the real individual issues and the people that are involved in these crimes.
10 seconds.
Oh, sorry. So pivoting to judge wouldn't be much different, because when we look at those cases, we get full reports of these people and we understand exactly what it is that they're looking for and what they really need.
So, I'm sorry, can you repeat the question? I want to make sure that I'm hitting all points of it.
Sure. So in just as opposed to a strictly prosecutorial mindset or punitive mindset, how do you take into account a person's veteran status, their PTSD possibility connections?
Okay. So as a judge, there are 5 pillars of justice that one needs to look at. Those are restitution, retribution, rehabilitation, incapacitation, and deterrence. So those are the 5 pillars that you're looking at as a judge when you're looking at how are you going to sentence somebody. We get pre-sentence investigation reports. We look at those pre-sentence investigation reports. We do get, I agree with my opponent here, that we do get to see what is the history of the individuals. But I'm taking into consideration all of those issues. So can I rehabilitate this person? Does this person have a drug or alcohol problem? Do they have potentially PTSD? I'm also very similarly aware of PTSD issues. My father was a World War II veteran. My grandfather was a World War II veteran. My husband was a Marine. Once a Marine, always a Marine. But he has his own issues that he deals with. And those are things that we all look at. We also have to look at retribution. When we talk about retribution, the victims that are involved, we also have to look at incarceration. So all of those things are things that I take into consideration when I'm sentencing. And if they are appropriate, sometimes I've even gone back to the prosecutors and said, is this something that we should be looking at Veterans Court for them?
Yadasha Jones, Veterans in Politics. So in Department 8, it has been heavily criticized in the in attorney surveys. Name one criticism that you believe is valid about this department, and tell me exactly what you have done or will do to fix that department, both of you.
Well, I have to say this. To the extent that it's been heavily criticized, I think you need to look at the statistical analysis on that. There were 5,660 surveys that were sent out. There were only 226 surveys that were returned. That's about a 4.7%. The median average of all of the judges was 72%. I received a 54.4%. If you work that out mathematically, it's about 35 more people that I would have needed to say, we like her, in order to get us to a 72%. The highest mark was 90%. That would have been another 70 people. So I think in the grand scheme of things, when you're looking at 370,000 people plus that voted for me the last time, I don't think that you can say 70 people out of that should be deciding our elections. That being said, one of the biggest criticisms was that I can be lose my temper. That is definitely something. Patience is something that I'm working on, and being more even tempered and being more patient with people. So that's definitely something that I'm working on.
So as far as the criticisms of what's going on in Department 8, I think that that's really one of the issues that I think my opponent just highlighted is the really lack of accountability when you're being told that, hey, there might be a problem here and there might be an ability to learn from mistakes. A judge needs to have the humility to say, you know what, sometimes I'm wrong and I understand that, but I want to get better. That's something that as attorneys we should all strive for, because we're not born right. You have to learn the law, and the law is a job. It's something you have to do every day, and you have to show up ready to learn something more. So secondarily, as far as the congeniality issues or the temperament issues, that shouldn't be something that a judge needs to learn. That's something that we all need to be able to do just internally. We need to treat people with respect and with just pride in ourselves. It's just not okay to treat people poorly or condescendingly. And that's something that I'm going to bring to the bench. I have a far more even-keeled temperament, I believe, than my opponent. And as far as learning from mistakes, I know I've made mistakes in my life, and I know what I don't know. So I think it's important to, like I said, every day, every case that comes in front of you is an opportunity to learn, and every bit of feedback you ever give is an opportunity to get better.
May I address one comment that was made?
No.
Okay.
Really time. My apologies. Andre Haynes, Armed Forces Chamber. This question is for both of you. Why should voters support you instead of your opponent?
I have been on the bench for 5 years. As I indicated when we first began, I have had 24 civil trials. I've had 3 criminal trials. All of those trials have gone to verdict. There has not been a mistrial. I bring a wide range of knowledge in both the civil and I'm learning criminal. I was brought into and brought onto the criminal bench at the request of our chief and other of the judges to help with the criminal bench. I jumped in, I'm learning it, and that's something that I pride myself on, is being a team player and helping out. I have been told by both the defense bar as well as the plaintiff's bar that I am thoughtful, I am always prepared, I know the law, and to the extent I will answer a little of what was said because I think it's relevant in this. I do learn, and I do bring that to the bench. I will also say, though, that objectively, my numbers show my reversal rate is one of the lowest on the bench. My preemption rate shows that lawyers want to be in front of me, and I will continue to bring that thoughtfulness, that preparedness, that well-learned 20 years of experience every single day and continue to treat others with respect and kindness, which is what I do.
All right, well, like Indiana Jones said, it's not the years, it's the miles. Prior to taking the bench, I will have had many felony jury trial experiences. I did 4 years working for several different judges behind the bench in district court for this exact same position. So I have been in a basic apprenticeship for the first 4 years of my career, learning how to be a district court judge. But more to your question about, why should the voters vote for you, is because I'm here for the voters. I am here for the people of Clark County. I understand that hundreds of thousands of people in Clark County make their living by working, and they work in the hospitality fields where I have worked. They work manual labor where I've worked. They work in sales positions where I've worked. I understand what it's like to live in Clark County, and I understand what it's like to be a voter. I have real, honest empathy for everyone who I see in my courtroom because I have to work with people every day. Some of the people that I work with are in the worst positions they've ever been in. They're victims of crime, or they are people who are new to the criminal system and they're scared. And you have to be that calm and gentle voice of reason with those people. And everyone that I work with, I am equally respectful for. And that's the same way that I'm going to treat everyone that I am seeing in court, and how I'm going to look at everyone that votes for me in the election is I am one of you and I am here for you.
Thank you. Morning, JP Edwards, Armed Forces Chamber. This question is for both of you. What aspects of your legal career have most directly prepared you to preside over this high volume, high stakes cases in the 8th Judicial Court?
So these high stakes cases, currently I work in the Major Fraud and Elder Abuse and Criminal Intelligence Unit. So my victims are usually the victims of crime exceeding $100,000 up into the millions of dollars. These are people who are in elder cases. They've lost their security. Someone has taken the money that they have saved for retirement that's supposed to last them for their lives, and now they're left with nothing. They're the victims of scams. They're the victims of thieves. They are people who are not hurt physically, but are hurt financially. So there's a lot at stake with these cases that I have to deal with. There are families that are destroyed. I have cases where there are hundreds of victims. There's a lot on my shoulders as far as making sure that people receive justice and honest recompensation for their injuries. The nice thing is that as a fraud prosecutor, I'm in a position where I can make people whole. And when we're working in these cases, we're trying to get real recompensation for all these things. Like I said, I'm a successful trial attorney. I have focused my career on getting as good as I possibly can and understanding the ins and outs of trial. District court is a trial court, and I bring that experience to the bench already. This isn't something I have to learn, and real trial experience is something that is invaluable as a trial judge. Evidence, appeal or appellate issues, you have to think of so many things all at once to make sure that these trials go off without a hitch. And that's what I think the voters deserve, is that someone who's done the work and can still do the work.
You want it? That's all right. That's all right. Can you repeat the question one more time? I just want to make sure I'm hitting it.
What aspect of your legal career have most directly prepared you to preside over high volume, high stakes cases in the 8th Judicial District?
So as far as the department that I'm currently working in, that I have been overseeing for the last 5 years, it is a civil, now criminal, and probate department. I am one of the 3 probate judges. I am one of the few probate judges who actually had a probate practice prior to taking the bench. As a probate judge, I dealt with some of the cases that my opponent, Mr. Beaumont, indicated that dealt with guardianship issues, that dealt with elder abuse issues. I also dealt with landlord-tenant issues, which I get appeals sometimes on landlord-tenant issues. As I said, I have 20 years worth of practice in the civil arena, practicing in all areas of the law. those are the types of cases that are before me every single day. I handled medical malpractice cases. I handled slip and fall cases. And I was a trial attorney prior to taking the bench. I did have 4 trials. One of the things that I like to say is that I didn't have a lot of trials because I settled a lot of cases, not because I was afraid to go to trial, but because I knew what the issues were on both sides, because I did represent both plaintiffs and defendants. I see that every single day as my job as a current judge, and I handle all of those cases with thoughtfulness, preparedness, and a willingness to make sure that everybody is heard and that their decisions, that my decisions, are legally sound, well thought out, and reasoned, and I will continue to do so.
How you guys doing? So I've been a victim of crime before, and I'm sick and tired of judges legislating from the bench, giving lesser than recommended sentences. We have a sitting Supreme Court justice that 70% of the time, if a pedophile goes in front of her and the attorneys have came to a sentencing, she will still give a lesser than recommended sentences. On average, you have people commit 11 crimes before they commit their first murder. Can you tell us that from the bench, you can actually stop these patterns from happening, and you won't let your heart or some kind of social justice BS, because the only thing that matters is justice. Will you tell us now that you can tell your voters that you will not do that from the bench?
Who do you want to start with? Okay. As I said, I received a criminal docket about a year ago. We are presented on a daily basis with negotiations that have been entered into between the prosecutor and the defense attorneys. We are instructed that generally we should follow those negotiations because the prosecutors and the defense attorneys usually know those cases better than the judges do. They know whether or not they're going to be able to be prosecuted or not. We do receive the pre-sentence investigation reports. Back in the day, those pre-sentence investigation reports used to have recommendations as to sentencing. Now we have to go based on the guidelines. And again, as I said when we first started, we have to look at the 5 pillars when we're doling out justice: retribution, incarceration, rehabilitation, recidivism. Those things are all of the things that we look at. I can honestly say the only times that I have deviated from the sentence that was agreed to between the prosecutor and the defense has been on the side of giving more time, not less time, than what was recommended.
So just to start, I believe that our judicial canons prevent me from saying how I would sentence someone in a particular case in a hypothetical situation. That being said, I respect the law more than my own ego. I am not a judicial activist. That's for the legislature to decide the laws. The courts interpret them and apply them. As far as sentencing decisions go, I've been a prosecutor. I understand the ins and outs of the criminal system and what needs to be done in certain cases. I understand that everyone is differently situated. Every case is completely different, and every case deserves 100% of your attention because every case that comes in front of you has hurt someone. Every case that comes in front of you, someone has done something to upset the balance of things. You have to be aware of how your decisions affect everyone. And at all times, you need to make sure that your decisions are in line with the law, and most particularly the Constitution, because good, bad, indifferent, we all have civil rights, we all have constitutional rights. And as a judge, you need to be aware at all times of the Constitution's guidelines about everything from the First Amendment through every other possible amendment. You need to be aware of the law at all times because it is more important than you and anything that you personally believe.
Another question? Sure. All right. Nevada authorizes cultural competency training for judicial officers, which includes understanding unique needs of veterans, such as military culture, trauma, and behavioral health, to ensure fair, informed courtroom proceedings. Have you completed veteran cultural competency training? If not, are you willing to do so and mandate it for your staff and so they understand how to communicate with justice-involved veterans?
That's a new one. I have never been informed by anybody in the courthouse that there is veterans cultural competency training. I would absolutely be interested in abiding by that and taking that and getting that information. I don't know that I can necessarily require my staff to do that. I think that would be their choice, but I would definitely encourage that. But I don't know that I can require it.
Yes, I would absolutely take part in that. I don't presume to know what it's like to be a veteran or a member of the armed services. I'm the only one of my brothers who didn't enter the service. I tried, but I didn't get in. So I know what it's like to be the family member of service members. So I have that limited understanding of the issues that they've told me about. But having actual training to have someone come in and break down what's important to veterans, how it affects people more than obviously my limited experience with my family, that would be something that would be invaluable. And as far as having the staff do it, absolutely. The staff are the people that are there in the courtroom interacting with the people in court every day. They are your arms. They are your representation. For them to be introduced to that kind of training would be fantastic. So, yes, absolutely.
Again, Yadasha Jones, Veterans in Politics. The Code of Judicial Conduct says judges must be open-minded and impartial. Describe a ruling you would make that your own friends or donors would hate, and why you would still make it.
I don't know that I can necessarily answer that, Ms. Jones, and the reason why is because I think that would get into potentially violating the judicial canons.
Give a brief synopsis.
A brief synopsis of what? Why it would violate the judicial canons?
Like, hypothetical.
Anything that you would ask me to tell you a decision that I would make that would come in front, that could be an issue that could potentially come in front of me, would violate the judicial canons in and of itself. I cannot do that.
So let's say we're talking about Nikes versus Adidas.
Okay.
Your friends don't like Nikes.
Okay.
I just want you to put some thought to it.
Okay, so the thought is that if Nikes are the law, then I'm going to follow the law. That's what my job is. It does not matter who is in front of me. It does not matter what my feeling is about the law. The law is the law. And if Nikes are the law, then I'm going to follow the law.
So if I think I understand your question correctly, what the question would be is really the difference between a question of law and a question of discretion. So judges have to always deal with A, matters of law first, but B, matters of discretion. Sometimes it just comes down to the judge's call, like you said, Nikes versus Adidas. So attorneys generally understand that sometimes things are just up to the judge's discretion, and you have to make a call. You have to say, in some situations, Nikes, and say, look, this is my call and I made it. And you've just got to make those apologies to the people that are pro Nike, because sometimes it really is just a personal call. It comes down to a discretionary issue. And yeah, you put on the black robe to make those hard calls. When it's not the law, you have to trust that the person on the bench is going to say, you know what, I understand your arguments, Mr. Nike. I understand your arguments, Mr. Adidas, but I'm going to have to go with Nike on this one because in my discretion, this is what I choose. I understand your points. They're valid. I hear you. 3 stripes are great, but I love the swoosh. And that's what it comes down to sometimes. It's just the ability to say, like, look, I'm sorry. They put me here to make the hard calls. I got to make it on this issue. So I'm sorry that this hurts your feelings, Mr. Ditas, but, I just got to go with the swoosh.
Andre Haynes, Armed Forces Chamber. This question is for both of you. How would you handle a situation where a major campaign donor appears before you in court? And you can answer first, Judge.
So one of the things that I did the last time that I ran is, and I'm doing it this time as well, is I don't have access to my bank account. I do know, obviously, when I receive a check from somebody that they are donating to my campaign. It's part of the thing that we have to do when we run is running takes money. And so, but under the judicial canons, it is something that I disclose and make sure that I can let both sides make a decision as to whether or not. So if I have somebody that's a major campaign donor and I have somebody on the other side that is not a major campaign donor, I disclose that, let them know that I can still be fair and impartial because, as I have said, the law is the law. It does not matter who appears in front of me, and I can set aside that bias and that impartiality. But other than that, ultimately, it is up to the other side that might not be the campaign donor. If they believe that I would be unable to be fair and impartial, then they can still ask, and I would take that into consideration. But generally speaking, the law is the law, and I am going to disclose as I'm required to, because there could be the view of the appearance of impropriety, and so I will make that disclosure, and then I will leave it up to the parties to decide.
Thank you.
Thanks. So the campaign donation system in the whole, lots of different people donate to campaigns. And as a judge, many people that come in front of you are going to have donated to your campaign. That's just part of the process. But that's not a pay-for-play system. For me, that is, thank you for donating. I appreciate your support. Now what do you have to say? What's your argument? What's the law? Because whether you donate to me or not donate to me is utterly irrelevant when you have a legal issue in front of me. If you come to me with a wrongful death case and your law is wrong, that's one thing. If you're coming in front of me with an argument about one thing or another, my decision is not going to be based on, well, did you support me in the last election? I think that's it's really retribution to other attorneys who didn't donate to you. And that's a terrible look. I would avoid any sort of appearance of impropriety. I don't want to be in any sort of situation where there's any sort of ethical concerns. As a prosecutor, we are held to a higher standard of ethics. It is an actual higher standard that prosecutors have to follow. I take that very seriously, and I would take that same higher ethical standard to the bench, because I know that I am representing not just the bench when I make my decisions, but the system as a whole. We can't be giving special favors and special attention to people who donate to our campaigns. That's just wrong. And the attorneys and people who appear in front of the courts all know that.
Thank you.
JP Edwards, Armed Forces Chamber. This question is for both of you. How do you ensure your rulings are grounded in statute and precedents rather than personal philosophy?
First of all, you read the statute. That's the first thing that you do. You read the statute, you look at the cases that are interpreting that statute, and you make a decision based upon the case precedent. If there isn't, sometimes we don't have, Nevada's a younger state, and a lot of times we don't have case law that is has been interpreted, and a statute has not been interpreted by the Supreme Court or the Nevada Court of Appeals. So sometimes what you will do is you will look to outside jurisdictions, see whether or not that they have a statute that is on point, that has the same words that are contained in the statutes that we have within the state of Nevada, and see whether or not they have any case law that might be persuasive. But the first thing that you have to do is you have to read the statute. Statutory construction tells us that if the words of the statute statute are plain, you read them and enforce them as written. Sometimes you have a statute where it can be vague or ambiguous, and then you need to look at case law to see how it's been interpreted, as I said. Also, you can look to if sometimes there are just simply words within a statute that are vague. You can look to, and it's not a defined term within that statute, you can look to dictionary definitions. There is case law that provides that you can look to dictionary definitions to decide what that word actually means. So that is just tenets of statutory construction of how you interpret the statute and what you look at when you're interpreting statutes.
So, as a trial attorney, I have appeared before the Supreme Court on several occasions, actually just a couple weeks ago. And when they're up there, all they care about is, what does Nevada law say? We're not looking at how do people in Kentucky feel about this issue. We're looking at, what did the Nevada legislature write? What does the case law say? What do the statutes say here? And it can be tempting to look to other jurisdictions and say, well, let's think about how the folks in Kentucky do it. But as district court judges in Nevada, we have to look at Nevada law, and we have to be respectful to Nevada law because we are the people who put the legislatures in place to make those laws. So you have to stay within the bounds of those laws as much as you can. Statutes are straightforward. Case law can be a little tough to interpret sometimes. Sometimes things are written a little weird. Sometimes bills are written, or laws are written a little weird. But as a judge, you have to be able to break that down. And sometimes when you can't quite figure it out, it's okay to ask other judges. It's okay to ask around. It's okay to ask peers. And it's okay to just do more work, because ultimately being a judge is a job. You have to show up ready to do the job. And it means long nights, long weekends, and honest research, because you're trying to make the best possible decision you can under Nevada law.
Frank Friends, Veterans of Politics. So the research is in on actually a lot of crimes. Like we said earlier, on average, people will commit 11 crimes before they commit their first murder. These guys usually get seen by you guys multiple times before these violent crimes happen. Should judges be held to account when they constantly allow felons back out into the street 27, 37 times before they rape or kill somebody? At what point does it start to fall on the judicial head who allowed this to occur?
I'll take that one.
Go ahead.
So, judges should absolutely be held accountable for their decisions. Like I was saying earlier, there's a difference between decisions of law and decisions of discretion. Now, when we put a case in front of a judge, the judge is ultimately responsible for a number of things that are entirely within their discretion. And when you see a judge who's exercising discretion in a manner that you disagree with, in any position, that should be noted. It's hard, unfortunately, in our system to understand what judges are doing until it becomes a problem. When you start getting media attention about the discretionary calls that you make, when the paper, when the news is looking at a judge and saying, why did you let this person out? Why didn't you sentence this person this way? Judges should be accountable, because when you, like I said, when you put on the robe, you are saying, I'm going to make the tough calls. And if you're not making the tough calls, or if you're making calls that people disagree with in some way, people should know. Unfortunately, unlike political records, it's hard to look up and say, which way did a judge vote on something. And unfortunately, those kinds of things that you're talking about happen when they become news and when they hurt people. So judges need to be aware every day that your discretionary calls, one way or another, are going to affect people. It's serious, and you should expect to be held accountable when your discretion hurts people.
I think that there's a very big difference between discretion and the law. And so, yes, there are discretionary decisions that a judge can make, but a lot of the times those discretionary decisions have sometimes been negotiated away by the prosecutors and the defense when they have presented a plea agreement to the judge that essentially says, well, this is what we have agreed to. We've agreed to an underlying sentence of this amount of time. So, yes, while there is discretion, that discretion is sometimes hampered by what is presented to the judge by the prosecutors and the defense when they're presenting you with a plea agreement. Again, you have to look at, if it is a discretionary decision, you have to look at balancing all of the factors that you need to take into consideration when you're making that discretionary decision. You can't just say, well, I'm going to put this person away because they did something bad, when we've got potentially a situation where you've got somebody that's got PTSD or has mental issues or has a drug and alcohol problem. So you need to take everything into account. And yes, we as judges do sometimes have to make the hard calls. I make those hard calls every single day of my life. But that has to be tempered with compassion. It has to be tempered with considering everything and everybody in our community when we're making those calls. And that's what I continue to do on a daily basis.
Thank you very much. I'd like to give you both 1 minute to make a closing statement.
You go ahead.
First of all, thank you so much for having me here today. This was great to be able to answer questions from you guys and see what it is that is most important to you, and I really appreciate this opportunity. As far as why I think folks should vote for me, and as far as why I think veterans should vote for me in particular, I know what it's like to work for a living. I know how veterans and my family make their living. I've seen it happen, and it's tough. There is, amongst all veterans, I believe, a call to service. I have been called to serve my community by being a prosecutor and by prosecuting crime. I've tried in every position I've ever held to be someone of service. I went into the hospitality management field because I wanted to serve, quite literally, and to help others. And as judge, I would be able to help the community and serve veterans and others even more than I'm able to now as a prosecutor. So thank you again so much.
Thank you very much for having us today. Thank you for your time. I have been on the bench for 5 years. I have served my community. I have many, many people that have come before me that have said, both defendants as well as victims, thank you for your time. Thank you for your thoughtful consideration. I had a woman a couple of weeks ago who said, listen to Judge Peterson. She's going to give you the opportunity to get your life together. She was telling this to the defendants that were sitting in the box. She said, they gave me an opportunity for probation. I now am clean and sober. I have my kids back. Listen to what she tells you. She will give you that opportunity. I continue to do that on a daily basis with a wide range of knowledge in both the civil field and now in the criminal field as well as the probate field. I also worked for a living. I've done everything from being a nanny to cleaning houses to being an attorney for 20 years prior to taking the bench. I serve this community. I work with the homeless population, and I do that on a regular basis as well. I've been a part of the Rape Crisis Center, and I will continue to serve this community both on the bench and do so with dignity and respect for everybody that comes before me, and with thoughtfulness and compassion. Thank you.
Thank you both for participating. This is the Joint Veterans Endorsement Interviews for Judicial Candidates. We'd like to thank our sponsors, Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, and Judge Jacob Reynolds in Department 29. This interview covered District Court, Department number 8. Thank you for watching and listening.